Federal laws, state laws, and case law haven't reached a consensus on whether an individual has a right to the wind. Within the field of energy law, the term wind rights hasn't been uniformly defined, and there isn't a national standard of what legal rights are associated with wind. Imagine that a landowner owned a 200-acre estate in a windy region. The landowner entered into a private lease with an energy company that gave the company the right to install large wind turbines on the land. The lease held that the company would have the exclusive right to convert the wind resources above the land into electricity. The landowner also granted the company an easement to build access roads and install electric transmission lines. This scenario represents the most common example of the concept of wind rights because the landowner had the ability to sell or lease his right to wind above his land to a third party through a contract. Although some state statutes specifically recognize wind rights as a property right, this right isn't recognized by every state. Recall that the ad coelum rule, which holds that a landowner owns everything below their land and the air above their land, can be used to determine a landowner's rights to coal, oil, or other minerals found under a landowner's land. The ad coelum rule can also be used to determine wind rights. Wind is air that moves through airspace, so wind rights can be allocated like airspace rights between neighbors. Although there can be limits on the ad coelum rule, it generally applies to the level of airspace above the ground that a landowner can occupy or use related to the land. This means that the owner of the land on the surface or surface estate is generally given airspace rights to the airspace above the surface estate.